explaining the only reason I was doing marijuana at the time was because of my cancer, my pain management for cancer. And I will promise you on Jesus' happy golden good soul that I will never touch the shit again if you let me go home.
Are you seriously going to stand here and talk like that?
No, ma'am. I didn't mean to. I'm terrified. I'm so sorry, ma'am.
Okay, so Miss Williford, in cause number 24, DCCR 1720, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 3rd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 5-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that...
We've agreed to go counts 3, 4, 7, and 8.
Thank you. 3, 4, 7, 8. Count 3 alleges that you provided a urine sample August 14th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes.
True or not true? Count 4 alleges that you provided a urine sample September 18th of 2025 that also tested positive for tetrahydrocannabinol. Is that true or not true? Count 7 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true?
Sure.
And then count 8 alleges that you are behind in your court-assessed fees as of September 18th, 2025 in the amount of $688. And is that true or not true? Did you enter your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand if I follow this agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Speak up, please.
Yes, ma'am.
And it looks like the agreement that you've reached is to remain on probation, but enter and successfully complete the special needs safety program. Is that your understanding?
Yes, ma'am.
And we've got probation here with us today, and is that the recommendation from probation as well?
Yes, ma'am.
Okay. I am inclined, if I follow this agreement, to extend the probation by some amount of time, just based on the allegations and the time that'll be spent there. So I want to make sure there's plenty of time after that she has still on probation. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Williford is not competent?
There you go.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. Looks like there's some, everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the special needs safety program as a condition of your probation. I'm going to extend your probation by 1 year, and this is going to be, hopefully, listen carefully to what I'm saying, okay? Because this is the second chance you're being given, and there will not be a third. So you need to take advantage of every opportunity that is being given to you. You're going to get help with drug abuse, you're going to get help with mental health, with everything you need to be successful when you get out of safety. If at that point you don't follow through and do what you're supposed to do, you're going to be back in here and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay? You're getting white. She's getting white.
I had the statement prepared for you, explaining the only reason I was doing marijuana at the time was because of my cancer, my pain management for cancer. And I will promise you on Jesus' happy golden good soul that I will never touch the shit again if you let me go home.
Are you seriously going to stand here and talk
No.
like that?
No, ma'am. I didn't mean to. I'm terrified. I'm so sorry, ma'am. I just didn't realize how much trouble I'd get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes, ma'am. I realize that. I was trying to...
There's all kinds of other ways to deal with issues, and there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now.
I'm so sorry.
Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Go back with the bailiff. For DCCR 2431, you're charged with the state jail felony offense of unauthorized use of a vehicle from October 15th of 2024. What that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1352, you're charged with a first-degree felony offense of aggravated robbery from September 18th of 2024. What that means in that case is if you go to trial and you're found guilty, the range of punishment is a minimum 5 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And then finally, in clause number 25 DCCR 1353, you're charged with the second-degree felony offense of robbery from September 18th of 2024. And in that case, what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then I have here on the tablet, in those cases, some plea bargain rejections that you've signed with Mr. Wilkerson. They show that the district attorney's office has made an offer, if you wanted to enter pleas of guilty, for a 35-year term in the murder case to run concurrently with a 35-year term in the aggravated robbery case, with a dismissal in the robbery as well as the state jail felony unauthorized use. Is that correct?
Yes, ma'am.
Do you understand what their offer is?
Yes, ma'am.
And have you gone over it with Mr. Wilkerson?
Yes, ma'am.
And do you want to reject that offer and have all 4 of your cases set for trial?
Yes, ma'am.
All right, is there any reason to expect that those offers would change any evidence that you're waiting on that you guys haven't received or gone over?
No, Your Honor, not at all. In fact, the state will likely be filing a motion to accumulate the sentences to the extent that we can. I think 3 of them would count by one occurrence, and then there's one from a separate occurrence.
You've actually got 3 different dates. So you've got ag robbery and robbery from September of 2024. You've got an unauthorized use from October of 2024, and then the murders from April of 2025.
To the extent we can accumulate all of those, Judge, we will seek to do so.
So I want to make sure you understand, Mr. Jones, that if you are found guilty in more than one of these offenses by a jury, the state can file requests that I stack or run cumulative, which means stack on top of each other any punishment that you receive. Do you understand that as well?
Yes, ma'am.
And that after today, I will not accept this agreement for a 35-year term. If you change your mind later, you can enter a plea open to the court, you can enter a plea to something different, but it's not going to be 35 years. Do you understand?
Yes,
All right, and do you want to have all of your cases set for trial?
yes, ma'am. I got a question though.
Yes, sir.
Like, it's my offer 35, right? Like, that's what the DA's offering, right?
Uh-huh.
My co-defendant admitted to it, but he got a 30-year offer.
Here's the thing. Your offer is what your offer is. He may or may not have had the robberies before he would, listen, I don't know. I know the offer is what the offer is. All right? So either you take the offer or you go to trial and let a jury decide. I'm not involved in negotiations. I'm not going to tell the district attorney's office what to do. That's not my job. But you don't get to, everybody has different issues in their cases that they feel important and why they would make different offers for different co-defendants. All right? So you're not going to have a different offer, and that's what I want to make sure you understand. Even though there was something different for your co-defendant, the district attorney's office has said, this is it, this is your offer. Do you understand?
Yes, ma'am.
Okay, and you want to reject it and go to trial?
Yes, ma'am.
Okay, we'll get it set for trial, and Mr. Wilkerson will be in preparation. You can go back with the bailiff.
Thank you, Your Honor. Be excused.
Thank you, sir.
Thank you.
You are Elazar Stansberry?
Yes, ma'am.
And Mr. Stansberry has been charged with the offense of murder. The case has been filed and not indicted yet. Mr. Burbank was appointed to represent Mr. Stansberry. Ms. Holmes has joined in just with regard to filing an application for writ of habeas corpus seeking a bail reduction. And so we set it for this hearing. Mr. Stansberry's bond is currently set at $1.5 million. And Ms. Holmes, you may proceed.
Thank you, Your Honor. Your Honor, I guess for, in regards to the case, we have limited information. All we have at this point is a PC affidavit, which is kind of generalized. I have met with Mr. Stanberry in regards to the allegation, and we do believe once we provide a packet, possibly once this case reaches the district attorney's office for the grand jury to review, then there may or may not be an indictment. We don't know at this point. Mr. Stanberry has been in custody since November 7th. I did meet with the intake division on yesterday. They do not have the case received at the district attorney's office at this point. It is still with the police department. And so we do not have a timeline on when this case may possibly come to the district attorney's office. Your Honor, Mr. Stanberry, with the current bond amount, we do believe that it is excessive in looking at the individuals, other individuals who are currently incarcerated. Mr. Stanberry has the highest bond at the jail, him and one other inmate. And looking at other individuals at the jail, especially those who have murder charges that are not indicted at this point, their bonds currently range from $250,000 to $350,000, and I do have those names if the court needs those. Your Honor, we are asking that in light of this, that Mr. Stanberry bond be reduced to a reasonable amount. He does have family here who will make sure that they secure his presence. Just briefly, although we don't have all the information, I can say from what I do know that in regards to this particular case, Mr. Stanberry did not flee. He's actually the one who called 911 after this had occurred. He was cooperative with law enforcement and providing his statement of events and everything that happened. So I do believe that that is a mitigating factor for the court to put into consideration, that we do not believe that he will be a flight risk if the court reduces his bond to a reasonable amount to allow him to bond out. Since this has occurred, Mr. Stanberry has lived in the area since 2020, in which he was relocated from a hurricane, in which he moved with, at the time, with his children, who do reside here in Beaumont with their mother, in which they share joint custody. Since this has occurred, Mr. Stanberry has lost that apartment where this occurred at his apartment. If he is allowed to bond out, he does plan, or is in hopes of planning, to live with his current girlfriend, who's here as well, with his parents. She lives at 25419 Richton Falls Drive in Richmond, Texas. And that is where he hopes that he will be able to reside if allowed to be released out on bond. Both of his parents are here. They're residents of Louisiana. His father resides in Lake Charles. His mother resides in New Iberia. But Mr. Stanberry does hope to be allowed to stay at the home in Richmond, Texas, since he doesn't have any ties to Beaumont except for his children at this point.
What's girlfriend's name?
Jazzy Starks.
Does Starks have any criminal history?
No, she does not.
Okay. All right, anything else?
And Mr. Stanberry also, he does not have any felony conviction history as well, Your Honor.
Okay. All right, thank you. Ms. Malfino?
Judge, I had the opportunity this morning to speak briefly with Detective Jackson. Obviously, he is not here this morning. If the court would like to hear from him, I would ask your consideration, because we have one more docket. If you would like to hear from him in person, if we could maybe hold on this until next week before any substantial reduction of this bond were to be made. I went with Ms. Holmes and we both visited with intake yesterday. We're both aware of the situation, that the case has not been brought in, although a warrant was walked through based on the facts they had at the time of the offense. I have brought that to the attention of the detective, not knowing if the case will actually fall in this court next door to whom it will be assigned. I have very limited amount of information, but I did make it very clear to Beaumont Police Department, and they were very receptive to the fact that this case even if it is absent some of the documentation, such as the phone download that the detective mentioned. It needs to be brought sooner rather than later to the district attorney's office, in all fairness to the defendant. But as the court has very limited information about the facts, I think there is going to be a dispute with respect to an affirmative defense versus an intentional and knowing murder. I don't disagree with that. I think the sides are not in the same position right now, but it's kind of hard to read between the lines with a 3-sentence probable cause affidavit. I think based on what this court has done recently and based on, Judge, just on the fact that every single weekend we turn on the TV and there's a murder in Jefferson County, I think that bonds in this county to protect this community, understanding of the defendant's rights, need to be substantially more than they have been in the past. And I think the court is beginning to follow, at least this court, is that trend. I'm not saying that an amount of relief is necessarily opposed by the state, but I don't believe, just based on what I know, Judge, and based on everything we're dealing with in this community, that something as low as $200,000 would be sufficient at this point.
My biggest concern at this point is the fact that this is from November 7th and you guys don't have it yet. And I think obviously the nature of the offense is we're tired of hearing about these offenses. It's the worst offense we can have. However, I mean, everybody has the right of being presumed innocent, you know, and we've got somebody sitting here for 30 days without a case even in your office, much less indicted yet. And I think that's a big problem that needs to be addressed. And it doesn't leave me a lot of, I think legally, probably required to do relief, because obviously the state couldn't be ready because you don't even have the case yet. And so that puts you guys in a bad position as well. Ms. Malfino, I think the facts are somewhat important, and I wouldn't mind hearing from Officer Jackson, however, or Detective Jackson. I just don't think that at this point, based on the time frame, that I can not give relief. Obviously, I think that the lack of criminal history is important. So that goes into this, because if we've got any type of criminal history, we'd be looking at something a whole lot different. I don't disagree with Ms. Malfino about what's going on in Jefferson County, but I also have to individualize each case. So that being said, I'm going to grant the relief. I am going to reduce the bond in this case to, $500,000. Condition of that bond if made, or conditions of that bond if made, are that Mr. Stanberry will be ordered to live in Richmond, Texas at 25419 Richton Falls Drive with Ms. Starks. Will be required to wear a GPS monitoring device and be on house arrest, other than for coming to court and for visiting with your attorney. Without my permission, you don't go anywhere else if you make that bond. If you've got doctors, if you've got different things like that, you get with Ms. Holmes, she gets with me, or Mr. Burbank, either one, they get with me, and then I either give you permission for that or not. Other than that, you're on house arrest with the GPS monitoring device. We'll know immediately if you leave the house without permission. The bond will likely be what it is now, if not more, if that happens. Are there any specific, I guess I don't really need to worry too much with a no contact, or because I'm going to have him on house arrest if he makes the bond. But obviously you're not allowed to be anywhere near that old address or anywhere near anyone who was involved that night. You're not to have any communication with anyone involved. So that doesn't just mean contact in person. It means you can't talk to them, send message to them, anything at all. Do you understand? All right.
Judge, I'm sorry, go ahead.
I just want, will his children be allowed to, I guess, come visit him? His children do reside with their mom here. Well, they
Yeah.
joint custody, but
That's fine.
they can visit him.
Yeah, I mean, there's no allegation that there was any issue with regard to the children, or that I can tell from the little bit of information I have. So whatever that, if they have custody, I don't have any problem with that. What were you?
Judge, I just wanted to ask the court to consider, for what it's worth, the order that he not possess a firearm or be in a home with any firearm. And also,
Yes.
I don't know how to request that you order this, but I would prefer, and I think it would be beneficial to the court and to the fact that this is a Jefferson County jurisdictional issue, if he obtains that GPS before he leaves here, so that
They'll put it on before he won't be able to leave jail without it.
somebody we work with, such as Johnny's, would be able to keep the
No.
court informed of his whereabouts.
It has to be, when we order a GPS, it's part of them getting out of jail. They don't get out of jail until they come put it on their leg there, I'm pretty sure. And so, isn't that how it works on GPS? I know not on drug patches, but GPS, they go put them on.
Before they get out.
Yeah, okay. So that gets taken care of through the bondsman, and they get somebody to get that done upon leaving or checking out or whatever happens there. Okay? So you are ordered not to be in possession of any firearm. If there are firearms in the home of Ms. Starks, they all need to be removed. So if you're going to live there, then you're technically in possession of that place. You can't have any firearms there. Make sense? Okay. We will... If there's any issue and the case is not received and indicted soon, obviously, this is something that would have to be revisited as well.
Yes, ma'am.
Okay, thank you. You can go back with the bailiff.